Morning, Your Honors. The matter before the court this morning is the case entitled Jason Herron versus Town of Guilford, case number 23 AP 402. Appellant Jason Herron is self-represented and is appearing by WebEx. Representing the appellee, Town of Guilford, is attorney Kristen Shamus.
Okay, thank you very much, and good morning again, everybody. Mr. Herron, can you hear me?
Can hear you loud and clear, sir.
And I can hear you, so you understand you have 5 minutes, and we'll give you an alert when you have about a minute left, so please go ahead.
Good morning, Your Honors, and if it may please the court, there are 13 reasons listed in my brief pointing to errors in the trial court's ruling. Due to restraints here, I have consolidated my time into 3 questions. I am pleading that this honorable court will answer those questions in its determination. First question, why did Select Board member Zon Eastis have to warn the Town of Guilford and then vote with the rest of the Select Board to access the fund in question? But when he became chairman, he was able to access the same fund without even notifying the Select Board. The trial court does not even mention the fund nor how it was accessed in its ruling to dismiss. Second question, the newly appointed town administrator claims she began redacting public information on behalf of the Select Board. How was she legally authorized to act on behalf of the Select Board if the board never met to discuss the topic? The trial court does not mention anything about the redaction of public information in its ruling to dismiss. The trial court does. Lastly, the chairman Eastis was caught holding 2 separate and unannounced gatherings of the Select Board with their appointed town administrator. When confronted, the Select Board chairman claimed that he was just distributing materials and assured the residents of Guilford that there were no discussions about public business while this public body was gathered. My third question is this, and I think it's the most important. Is there an exception in Vermont's open meeting law that allows the unannounced gathering of an entire public body for the purpose of distributing material? If so, then there's absolutely no way to enforce Vermont's open meeting laws. A public body could gather whenever they wanted and without any public notice. If they were caught, which is extremely difficult to do, one of them would simply claim they distributed some form of material and there were no discussions. End of the debate. Allow that same scenario in all remote form, and there is no way to stop private gatherings of public bodies. That scenario is happening where I live, and I have explained it in detail, yet somehow the trial court dismissed it all without even addressing one of those concerns. In fact, the trial court's premise for its entire dismissal is based on a false quote. I never said this, that neither a Select Board member nor a town administrator may seek legal counsel about town business without running afoul of the open meeting law. I never made that claim, ever. That statement was fatal for not only misquoting me, but it metastasized into every opinion in the trial court's ruling. I explained that the Select Board chairman had several methods to seek legal counsel without accessing the fund in question. I even point specifically to the legal services provided through Guilford's insurance company, the VLCT, which offers the same services Eastis required without the improper access of a public fund. Without some further explanation, no one can be sure how the trial court came to write that false quote. And now this oversight has been clearly pointed out. What effects did it have on the rest of the ruling? With that said, I'd like to reserve the remainder of my time.
Okay. All right. Thank you, sir. We'll hear from counsel for the appellee. Please identify yourself and your client and then proceed.
Good morning, Your Honors, and may it please the court. I'm Kristen Shamus of Monaghan Safar, and I represent appellee Town of Guilford Select Board in this matter. The town asks today that this court affirm the Superior Court's Rule 12b6 dismissal of Mr. Herron's 4 separate allegations that the town violated Vermont's open meeting law. The trial court properly dismissed each of these 4 claims and granted the town's motion to dismiss, holding that Mr. Herron failed to state any cause of action in his complaint. In Mr. Herron's first and third claims, he argues that the Select Board Chair and the Town Administrator each violated Section 312G of the Open Meeting Law by seeking legal advice from the Town Attorney without authorization from the full board at a public meeting. Appellant claims town officials are allocating taxpayer funds outside of a duly warned meeting unless they seek specific full board approval for each and every question they ask the town attorney, even when the board has approved an engagement agreement with that town attorney. This idea is both unreasonable and entirely unsupported by law. Under Section 872A of Title 24, the Select Board is responsible for the general supervision of the affairs of the town and authorized to perform all duties required of towns. These duties include the responsibility to seek legal advice when the official deems it necessary. In Burton v. Norwich, this court held it's within the scope of the implied powers of town officials to protect the town's interests by employing counsel. Even if this were not the case, the town appropriates funds for legal services in its budget each year, meaning these funds were allocated before any town official reached out to the town attorney for legal advice. Under either argument, appellant's first and third claims fail and were properly dismissed. In his second claim, Mr. Herron argues the 5 minutes he was allotted to speak at a select board meeting was insufficient and violated Section 312H of the open meeting law. Section 312H, however, requires only that the public be given a reasonable opportunity to express its opinion and permits the board chair to establish reasonable rules for public comment. The select board complied with 312H by allowing 5 minutes per speaker during public comment, and the Superior Court correctly held that the open meeting law does not require more. Mr. Herron admits in his complaint that he was allotted 5 minutes to speak and that he wasted some of this time by asking the board questions that it did not answer. Just as it is here today, it was Mr. Herron's responsibility then to determine how best to use his 5 minutes, and he chose to interrogate the board with some of his time. The board's under no obligation to respond to questions posed to them during public comment. Mr. Herron may have preferred that the select board engage him in dialogue or allow him unlimited time to speak after each agenda item, but these are simply not open meeting law requirements. The board fully complied with the law, and the Superior Court properly dismissed this claim. Finally, in his fourth claim, Mr. Herron seems to argue that the select board violated open meeting law when the board chair asked members to remain at the end of a meeting so he could distribute organizational materials. Appellant claims this falls under Section 310(3)A's definition of meeting, which is a gathering of a quorum for the purpose of discussing the business of the public body or for the purpose of taking action. He interprets Section 310(3)C to mean that any gathering of a quorum is a meeting unless it's a social gathering, convention, or other type of specific gathering described in the statute. But he ignores the additional language in this section, which allows a quorum to, quote, otherwise gather. Section 310(3)B goes further to specifically state that a meeting does not include communications for the purpose of scheduling a meeting or distributing materials to discuss at a meeting. Under Mr. Herron's interpretation, the select board can only distribute materials outside of a quorum, although that's not the plain language of the statute. Here, the select board's organizational communications fall squarely outside the definition of meeting. Mr. Herron may speculate that the select board must have held discussions that went beyond passing out organizational materials. There's no evidence of this in the record. Mr. Herron concedes in his complaint at AV 166 that the select board confirmed at a later public meeting that the chair had only distributed organizational materials. A claim under Section 312C requires more than mere accusations and speculation, and the Superior Court correctly dismissed this claim. The town has not violated the open meeting law, and this court should affirm the lower court's decision. With that, the town will rest on the arguments in its brief. Thank you.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 43 seconds remaining.
All right, thank you. Mr. Herron?
Your Honor, in my brief, I pointed to an unredacted legal invoice issued by the law firm representing the town here today. That invoice proved Chairman Eastis wanted to know if he had the authority to call for a recess without a vote. I happened to be on the select board's agenda that evening. At that meeting, Eastis refused me the right to speak on 2 separate occasions concerning public documents. My name was invoked on both occasions, and other residents were allowed to engage with the board, but not me. When my agenda came to the table, I was silenced after 5 minutes in mid-sentence by an alarm and instructed to stop speaking. When residents of the town offered to donate their time for me to continue, Eastis called for that recess.
You have 1 minute, sir.
Once the chairman was confronted about his motives for contacting the law firm, all future invoices were redacted. When I questioned how the town administrator could redact an invoice concerning the Guilford Free Library addition on behalf of the select board, without the select board meeting to discuss it, the town administrator contacted the same law firm representing Guilford here today. From there, Chairman Easton started having all remote and completely private gatherings in order to distribute material. Look, I am clearly not a lawyer, but I believe I should get a fair day in court to express all of this in detail. And the fact that we are making communications between members synonymous with the gathering of a quorum is a big problem. And with that, I rest my case.
Okay, thank you very much. Please call a conclusion of the hearing.